It was in the list of yesterday list, item number 1.
Tomorrow.
My lord, great.
Yes, call the list.
My lord, I have advised Mrs. Maiti to file an application in the alternative under Article 227. As he used to do, my lord, in case of demand order, where we were in controversy.
File it.
That
File it.
But not, my lord, this week. She is in some difficulty. She will.
I am in difficulty because from next week I am there in Jalpaiguri. So I automatically adjourn for 15 days. Yes, not this week.
Yeah, not this week. Just at action.
Then today no order.
Alternative for a file.
Adjourn. Oh, আচ্ছা।
কত তারিখ দিয়েছে?
That is
This is my application for review of your lordship's order, solemn order dated 11 May 2023.
Have you filed?
Section, there's a 10 days delay. I have filed section 5 application.
Have you filed?
Which has been registered as CAN 2 of 2020.
Correct.
10 days delay. I have explained, my lord, if your lordship kindly consider first that due to, my lord, they sought for legal opinion and
Yes.
that
Have you also filed an application for review?
lordship, CAN 1.
Can.
Lordship. But let me place one of the petitioner, one of the applicant, the review
Just one
applicant,
minute.
if your lordship is one of the respondent.
First thing is condonation.
Oh, no, very good. Paragraph 5, I have stated. Ostately is 81 pages and my petition is 2 pages.
Paragraph?
Paragraph 5, we have explained. Let me read out. The original applicants paper.
Just 1 minute. Yes. Yes, delay condoned.
Grateful.
I won't oppose that.
No. This is an application, CAN 2. This is an application for condonation of delay of 10 days in filing an application for review. Stop. It is a word in the instant application that after the order dated 10/5/2023 passed by this court and uploaded on the official website of this court, the file was sent to the legal department of the Southeastern Railway, and on 5/6/2020 the law officer has given his opinion to file a review against the said order. Thereafter, the file was sent to the Ministry of Law and Justice for taking necessary action. Subsequently, the lawyer was engaged to prefer a review, which was communicated on 7/6/2023. Thereafter, the entire documents were handed over to the learned advocate to prepare a memorandum of review and the application, which in fact was done and sent for settling to the senior counsel on 10th June 2023. After the memorandum of review is settled by the senior counsel, immediately the steps were taken to file the same and by this time there is a delay of 10 days. Considering the explanation to be sufficient, next paragraph, considering the application to be sufficient, we allow the application, comma, the delay in condoning, delay is in filing the review application is hereby condoned. Office is directed to formally register the review application. Full stop. Yes, what are the grounds of review, sir?
Yes. Grounds, my lord, I have stated in ground number 2, 3, and 4 the relevant grounds of my review applications.
Just one. Grounds number
2, 3, and 4.
of yes. Whether these
And my lord, kindly consider
just 1 minute.
4 and 5 also. Ground number 4 and 5 also.
Correct. Yes.
Now, my responsible submissions, my lord,
Yes.
on the same cause, my lord was pleased to pass an order in 2021 saying to follow the guideline framed by the another coordinate bench presided over by the Justice Dipankar Dutt. My lord, that is that order has been passed by Justice Dotto, the guideline frame in WPCT 74 of 2016. After passing of this order, which is today is placing before your lordship for review, we have come before your lordship. Another coordinate bench presided over by Justice Venumani passed an order, and whereby my Lord Justice Venumani was pleased to differ with your lordships and said follow the guideline framed by Justice Dotto. So my responsible submission, my lord, this is fit case for recalling or review to exercise the power of review or jurisdiction of review.
When the order of Justice Velumani passed,
My lord, that is on 16th June and 21st June. On the same
that is subsequent to the order.
subsequent this order.
Subsequent to the order. Can a review lie on that ground?
But
I'm asking you.
I'm my lord,
Suppose a ratio laid down in a judgment has not been accepted by the court and has laid down the ratio subsequent thereto.
we have cited.
Does it mean the review would lie?
But
I'm asking a very simple.
very simple. I'm humbly submitting before your lordship, my lord, since it is a post facto, the order passed by the another division bench. But as a matter of fact, the order what was passed by your lordship on 11 May, prior to that, 3 judgments have come out.
Correct. Show us those 3 judgments.
Yes. My lord,
Before that, my lord, may I submit one humble submission?
let me conclude.
Please let him conclude.
Because they have
Mr.
said, we do
Mr.
not
Samat.
intend.
Lordship,
Let him complete.
grateful. Supreme. 1721, Justice Robinson Division Bench. 1721.
You said because never decided. There is nothing because increment nature.
আগে my lord এটা দেখুন। At first, my lord, kindly consider my lord's order. Passed on 29 January 2020. Justice
আচ্ছা কপি আছে
Senate. No,
আমার কাছে কপি আছে
copy.
Yes.
again petition.
What does it say?
My lord said, at first, my lord, page 2, the order passed by Justice Dotto's Division Bench set
Correct.
out.
Correct.
Then next para. It is the grievance of the writ petitioner at this stage that though the writ petitioners have complied with directions number 1 and submitted documents within due time, the screening committee refused to consider the said documents showing minor discrepancies.
Correct.
Mr. So-and-so said the submissions recorded in view of next para, in view of filing of the supplementary affidavit, we are of the considered opinion that purpose of writ petitioner shall be achieved if the alleged contemners are given an opportunity to consider the supplementary affidavit in accordance with law. It is of course open to the alleged contemners to arrive at an independent decisions on due consideration of the documents annexed to the supplementary affidavit.
Correct.
Therefore, the learned advocate for the alleged contemners is requested to place the supplementary affidavit before the.
Where is the ratio let down in there?
But here, my lord.
Question
because
was,
it was arising out of
there
the
was a,
contempt proceedings.
please consider, the question was, there was a scheme or whatever
Yes,
that was created.
lordship.
It shows the clause 1 says that within 7 days from the date of the
Yes,
copy of the judgment, they have to produce a document.
lordship.
It appears that you were taking a very technical view and finding out minor discrepancies in those documents,
Lordship.
filing of the documents. We have said that no, these minor discrepancies should not come in the way. You have to consider that the case as if the documents have been filed to them. Then you said that the screening committee has now been dissolved. Then we said that no, for this purpose, you will set up a further screening committee and will take a decision in accordance with law.
In terms of order,
No.
last line,
Sir,
in my
sir,
understanding.
what first line?
Last line of the order.
Yes,
The
independently.
screening committee is directed to act in terms of the order dated 8 February.
Correct. What was
29,
there? What was there?
the
That
guideline?
within, please, what was there? Within 7 days from the date of the judgment, the respondent number 1 intimate the petitioners that what documents are required to be placed. Second is within 1 month of such receipt of the intimation, they will appear before the chief personal officers and with all the documents and shall be placed before the screening committee.
Lordship.
And the third one was that since the land losers have been offered appointment even after 47, citing a relaxation, that has to be done. Fourth says the entire exercise should be completed. Now, it's a document which is required to be placed. This is the order of the court. They have placed the documents. It is not that they have not placed the documents. Then I said that in that judgment, rather, I can say I said, because my brother was
Yes.
not there.
Division.
We said at that point of time, the screening committee will continue and decide it. This is the judgment. Here, in this judgment, what we said is, there is a scheme framed in terms of the order. I have said that you took a stand that paragraph 5 has to be read in a meaningful manner,
Lordship.
which includes that even in case of a person coming under the said scheme, this is what is there. He must fulfill the eligibility and other conditions prescribed for the post. This is silent.
Lordship.
It does not talk about those
Absolutely.
concepts. Then for the post against the direct recruitment quota from open market. It is further contended that the power to relax any of such conditions have been bestowed upon the general manager of the railways. And therefore, there is no justification in the apprehension of the writ petitioners that the physical efficiency test was never an integral part of the entire screening eligibility of the land losers. We find that such being the core issue and was in fact raised in a different proceedings, but appears to have been decided differently. We have taken note of those.
Yes.
Some of the orders passed by the tribunal as well as the court reveal that the direction was passed upon the railway authority to proceed with the physical test as well as the medical test, whereas the point has been taken that those observations or orders being interlocutory in nature cannot be construed as a final adjudication, which would further be seen from the expressions used therein, that such procedure shall be without prejudice to the rights and contention of the parties. At the first blush, we are taken to aforesaid orders in order to find out whether any ratio can be culled out therefrom. But subsequently, the moment the Council for the Railway disclosed their stand, we feel that there is no necessity of going into the nuances of the proposition of law, as the railways have shown their inclination to keep in their mind the object and purpose of benevolent and welfare scheme provided to such land losers. It has been clearly submitted by the Council appearing for the railways on instruction, having received by a competent person present in court, that even a land loser who does not qualify the physical efficiency test, he has not been debarred from giving an appointment under the said scheme if the medical test indicates that he is otherwise fit to render the services attributable to the posts to be offered to him. It was all along the stand of the writ petitioner that the physical efficiency test was never introduced, and it has only on the basis of the medical test the appointments have been done for more than 400 such persons. The stand of the railways, as it appears from the submission made before us in this regard, that the physical efficiency test was not insisted for appointment of those persons by mistake, and therefore a right cannot be accrued to a person on a mistake discerned subsequently. Be it that is may, we do not intend to enter into the aforesaid aspect. The moment the railways have decided and conveyed to the court unequivocally that even a person is not qualified in a physical efficiency test, will still be considered. We never say appointment, still be considered for appointment on medical test, which is distinct and different from the physical efficiency test. We do not think that anything more is required to be gone into this. This was a very categorical stand of before us when the writ petition was disposed of. Now, if there is a change of opinion, if the change of mind, does it invite a review to be filed?
No,
I am
we have
just
come before your lordship today that
I am asking
we are
because
not
this
saying-
order was taken into consideration. That this order
I'm
actually
coming.
does not apply.
Other
not
orders are
apply.
there. I'm coming. Other
Does not
orders
apply.
are- Let me place.
Does not apply.
Yes, the justice says.
Now tell us.
But-
Review, you know.
Yes, scope is very limited. I'm not saying there is an error apparent on the face of record.
You are not
because of-
saying.
No, because of the court's mistake or whatever may be, error on the part of the court. It was misconception of facts based on which it is on our part, based on which this order has been passed by this honorable court. That is my humble submission. For that reasons, we are inviting your lordships to exercise the jurisdictions of review for the recalling or review, whatever may be, as your lordship may seem fit and proper. Now, here, my lord, the case is this order.
Because
My lord has
we
come
were
to-
conscious when you were making a submissions, we said that who is giving you an instruction.
Yes,
And we recorded it.
lordship.
That a person who was present has instructed you to submit this. It is not that we did not. Our language is very clear. We were conscious.
I
We were
candidly say
conscious.
so. I candidly say so.
And
because-
it is
No, the
available
point
in the
is-
live streaming.
Please, sir, kindly. continue.
Sorry, don't put it nowadays. The live streaming are used
But-
as an evidence. How can you use it? That's a larger question to be decided.
That will be decided by
Sorry.
Supreme Court. Milord.
Whether it
But
can
it
be
will come.
used
It will come.
every time 4 hours, 35 minutes, 36 seconds and sub-seconds.
Well,
Do not
since
go
my
by that.
point is, since there is an error apparent on the face of the record, according to our the perceptions, that if we could have placed these orders passed by
These orders were placed.
This
you
order,
are
my lord's
relying,
order,
then we are saying that this order has no relevance so far as this issue is concerned.
very well. Same issue, on the same issue, Justice sends.
That was all produced before my lord. And ultimate, my lord, this is a ploy. This is a ploy. 3 months they were given time. And your lordship clearly said,
Oh, wait. This
We
is,
could not
this is
submit on the day. because
on
we
the
are not
day.
Ready at all.
Hey,
Another.
আমাদের original writ petitions টা আছে,
কোর্টে রেকর্ডে থাকতে হবে।
original writ petition এ file টা আছে?
আমার কাছে আছে, আমি দিয়ে দিতে পারি।
No.
কোর্ট রেকর্ডিং।
Oh, noting, your lordship.
No,
noting.
এটা can 1, can 2 or review. Original টা কোথায়?
আছে তো।
Writ petition? Where is the original writ petition?
কানেক্টেড। সো এটাকে সরাও এবার, যেটা হয়ে যাচ্ছে সরাও, এখানে রাখো। জাস্টিস সেনের অর্ডারটা কোথায়? 11-11।
Original writ petition WP CT 88 of 23 কোথায় আছে? আনাও। এটা disposed of হয়ে গেছিল on 7th of July. না, 7th of July নয়।
11th May.
May.
That is there in the file is there, as I could ascertain.
No, where is the file of, এটা ফেরত দাও।
Read petition.
এখন দাও ফেরত, writ petition এ ফাইলটা দাও।
Review এর সঙ্গে মেন ফাইলটা এসছে, নিশ্চয়ই আছে।
No, I have said that do not automatically include the main file. The difficulty is the moment the main file is listed, the main file is also shown as pending. Though actually it has already been disposed of. So system is a bit, there is a,
আরে যেটা রাখো না।
is file, where is the file? Call for the file. তুই বলেছো সেখান টেস্ট করে দেবে স্টিল কি করেছে
এটাতে কোনো অর্ডার রেশিও ডিসাইড করেন সব। এটাতে করছি।
এক্ষুনি নিয়ে এসো
এসএলপি অর্ডারটা দেখো যেখানে বলে
Lord, your lordship is wanting to see the orders passed by my lord justice sent. Show mention.
is it included there? So
এটা একটু জজকে দেবে।
no, it is included in the writ petition, so that was placed because we recorded that
Lordship.
the several judgments, different judgments have come. Some says this, some says this.
And it is interlocutory.
Sorry, you can't say. We noticed it correctly, wrongly. We have deviated. Your right is somewhere else, but the review on that ground will not lie. If the court has considered the judgment and interpreted in a particular way, which may not be correct or may be correct, that does not mean that the review would lie.
Because review lies my humble in my understanding, so
Yes.
far provision is concerned. If there is error or is a error on the facts or the laws on my part, so due to
Sir,
misconception of facts on the part of the council.
Sir, you are really opening the scope of review
No,
to
I'm-
that height.
No,
Sir, the error does not mean an error of fact and law. The error must be apparent on the
the face.
record, on the record.
This is a court of
If-
records.
Please, when on the record, something is there and the court omits or did not consider that, or there is the finding is absolutely, the whatever is from the record, it is contrary, then in that event, not contrary, when that has not been considered at all, then you can ask for a review. But if those facts have been considered and the court has arrived at its independent finding, the finding may be correct, the finding may be wrong. Whether the review lies,
Then
then
why-
you can go higher up and get it corrected.
Before that, minute, I am trying
What
my,
more?
I am trying my minute, this, our minute,
Sorry,
this, one
No,
of this
you can't.
tire. This is one
Then
tire.
every time the review.
But why minute the few judgments and orders of the Honorable Supreme Court even in this matter have not been placed on the date.
I am simply, suppose you did not place the order. That does not mean you can go and get it corrected higher up.
If I am, I'm not-
If you do not do that, then what to do? It's a second round of hearing. Is it permissible? Review is permissible for that.
5 minutes, I am.
Second round of
drawing-
hearing.
I am drawing invitations of your lordships. Because if your lordship could have considered on the date, Supreme Court decisions reported in 2019, but in Shankar Prasad Deep's case on the same issue. Supreme Court said, whatever may be the guideline framed by the railway authorities pertaining to land users category for appointment, that has to be followed and High Court should not interfere. I could have placed because
Sir,
on
in
that I
this
was not well
judgment-
equipped.
Please, have you realized in this judgment, we never say that the scheme shall not be followed. Please look at the observations in
But
the order.
kindly is
Never said so.
that is the
Sir,
we are in trouble.
please,
Great
no,
trouble.
you are, that is a problem, I tell you. what it
absolutely correct.
says.
We are in trouble. Vinod.
Please. Please come to page 2, the second paragraph. The dispute arose
Yes.
when a large number of persons lost their land in acquisition proceeding having initiated in this regard, and considering the plight of those persons, and in order to succor to a sudden shock which they faced, a benevolent and a welfare scheme was framed, being RB number 99 of 2010.
Yes.
For giving an employment in the railways under the land losers category, and a screening criteria have also been provided therein. We have taken note of that particular scheme. The parties are at variance, then we have said. So far on the applicability of the conditions relating to procedure postulated in paragraph 5 of the said scheme, that is, say that the parties are not ad idem to that, they are at variance. According to the writ petitioners, the procedure which is consistently followed by the railway under the aforesaid scheme has been diverted to a more rigorous procedure, rendering several eligible persons under the said scheme to be kept out of the purview of the scheme, outside the purview of the scheme. In other words, it is sought to be contended all along the railways, they all contended all along that the railway had adopted the procedure of screening the other documents and never imposed any of such land users to undergo a physical efficiency
Yes.
test. This is where the variance was. Whether he has to go undergo a physical efficiency test or not go. That is, scheme was never challenged.
Lordship. As on date.
No, they are under the scheme also. They are saying we are coming under that scheme. Then, in support of the aforesaid contention, it is further contended that the joint procedure order dated 3rd June 2011 does not recognize with the physical efficiency test, and therefore a sudden imposition after the order of the tribunal is an overreach act of the railways authorities tainted with malice, which can be perceived to be a contumacious act, exposing the authorities to be punished under the Contempts of Courts Act. This is what they say. On the other hand, the Council for the Railways, means you appeared,
Yes.
took a stand that said paragraph 5 has to be read in meaningful manner, which includes that even in case of a person coming under the said scheme, he must fulfill the eligibility and other conditions prescribed for the post against the direct recruitment quota from the open market. It is further contended that the power to relax any of such conditions have been bestowed upon the general manager of the railways. So you have contended that, and therefore there is no justification in the apprehension of the writ petitioner. What do you say? That power to relax is there, that can be taken care of. There cannot be any apprehension in their mind. That the physical efficiency test was never an integral part of the entire
Kindly
screening
pause
committee.
for a moment. Here is wrong. On my.
Please, apprehension that the physical test was never an integral part of the eligibility criteria.
Was an integral.
No. Now, we find that such being the core issue and was in fact raised in the different proceedings, but appears to have been decided differently. That means the different orders were placed before us
Only
by
one.
you.
On that.
No,
Yes,
say.
I say so.
Some of the orders, then why we will write it? Some of the orders passed by the tribunal as well as this court reveal that the direction was passed upon the railways authority to proceed with the physical test as well as the medical test, whereas a point has been taken that those observations or orders being interlocutory in nature cannot be construed as a final adjudication, which would further be seen from the expressions used therein that such procedure shall be without prejudice to rights and contention of the parties. This is what we perceive from those orders. At the first glance, then we say, we are taken to the aforesaid orders. Again, we have seen orders in plurality. It is not an order.
Yes.
In order to find out whether any ratio can be culled out therefrom. But subsequently, the moment the Council for the Railway disclosed their stand, we feel that there is no necessity of going into such nuances of the proposition of law, as the railways have shown their inclination to keep in their mind the object and purpose of benevolent and welfare scheme provided to such land users. So we have upheld that scheme. We said that you are taking shelter under the scheme and the scheme has to be applied. It has been clearly submitted by the Council for the Railways on instruction, having received by a competent person present in court, that even a land user who does not qualify the physical efficiency test, he has not been debarred from giving an appointment under the said scheme. Please, if the medical test indicates that he is otherwise fit to render the services attributable to the post to be offered to him, means he has to undergo with the physical efficiency test. And if he qualifies, no problem. If he does not qualify, then your stand was that we will not debar him. He will undergo a medical test. And if the medical test proves that he is otherwise eligible to render services to the post, he can be offered a post. This is what the sum and substance of this judgment is.
That is troubling.
Then
With that part only.
no,
Debarring, this word.
no.
That can't be debarred that I have submitted. That is wrong.
No,
On my
I
part.
do not. It was all
agree.
along the stand of the writ
Agree.
petitioner that the physical efficiency test was never introduced, and it has only on the basis of the medical test, the appointments have been done for more than 400 persons. That is what they say.
Yes,
The stand of the railways, as it appears from the submission made before us in this regard, that the physical efficiency test was not insisted, means it does not mean not followed, insisted for appointments of those persons by mistake, that you say And therefore, a right cannot be accrued to a person. Means when you say that physical efficiency test, you have not taken for these 400 persons. If those have been done by mistake, that does not accrue any right to them. We were conscious. You were correct. The mistake does not confer a right. Then we say, then be that as it may, we are not intended to enter into the aforesaid aspect the moment the railway has decided and conveyed to the court unequivocally that even a person is not qualified in a physical efficiency test, he will still be considered for appointment on medical test, which is distinct and different from the physical efficiency test. Means they have to undergo a physical efficiency test, and in the event they fail, then they will be provided a medical test again. If the medical test shows otherwise, then they can be given an appointment. This is
Otherwise, that is giving us trouble.
what
That I said so, that has been recorded by your lordship based
Correct.
on my submission.
correct?
That is error, that is not,
What?
if
What
it
error?
disqualifies, then that can't be debarred. The word debarred,
Oh,
I said
that
so.
that is a different stand. Debarred means that subsequently the second paragraph will, there is no word debarred. The word is he will still be considered
Still be considered
for appointment on medical test.
on medical.
That's all.
If he disqualifies in medical test, matter goes.
Go. No difficulty. Who says a person who is otherwise not medically fit, will you give him an appointment? What are you talking? No sensible man would take it. No sensible man. You have to read the judgment in that spirit. The subsequent one is very clear. And that is your stand.
I bow down to your lordship.
So,
Only thing, the two things are troubling us. That is why we have.
sorry,
come to your lordship.
don't go
One
by
is-
those words, debarred.
One is debarred.
No,
And
sorry.
second is the person who was present in court and instructed me, he was not capable or not. I think so. You said so in the ground.
You can't
That
show
he
it.
was not
Sir,
able to
then,
give me
then
instruction.
today a gentleman has come who has given an instruction. Again, tomorrow you will come and say he was not competent enough,
So
not
today, I
authorized.
have said, today we are now,
Sorry.
have come with all the orders passed by this honorable court.
You
time
can't,
to
you
time.
can't, you can't
Even
reopen, you can't reopen
Another
the issue.
things that are troubling
You
us.
can't reopen
Even
the issue.
after passing of this order on 11 May, another coordinate bench passed a different order.
Maybe
So
that is
we
a
are in
different
trouble.
one.
There must be some
Look at,
uniformity.
look
in
at
the
it.
order.
We could lay hand to these judgments which you cited from the original file.
Yes,
Till
Yes.
this time, you have not handed over.
absolutely correct.
Yes.
Justice Sen's judgments
So everything is there.
and one or two tribunals order.
Sorry, everything. Justice Sain's judgment is here.
That is an order.
Then the administrative tribunal
Yes,
judgment is
that's
also
how
here.
I remember that.
Yes.
What I said.
So what more?
More is here. My lord's order, I couldn't place. In my understanding that my lord in 2021
That
said
is a
so,
different. That
follow
is
the
not a
guidelines
different.
of Justice
We
Dotto.
will clarify.
And also, my lord,
Will
I could
clarify.
not place Justice Dotto's order. That is the.
That
parent
is
order.
also recorded there.
No, my lord,
In this order, it is recorded.
in that
What-
order, it has been recorded.
Recorded. So we'll say that what Justice Dotto says and how it is relevant in the present case.
Same order. Same thing, same cause. That's why the Justice Dotto framed this guideline, my lord. Kindly consider these things.
Sir, may I give you a hypothetical example? What you are saying is that since it relates to land loser, so every case is equal. No. No. I give you a very simple example of the civil case. A landlord has filed a suit against several tenants, composite suit. Or say different suits. In one of the suit, the ground of subletting was proved, saying that the tenant has
The
not
default
been
of
able to
whatever.
prove that he has not sublet. In another case, the subtenant has already given a notice under the provision of the act, and then he acquired some protective status. Can you say that, look, already it has been held that he is subtenant, he has
No, facts are different.
So here also, he is a subtenant admitted, but the difference is the notice. Whether that subtenant has given a notice or this subtenant has given a notice. It appears the one who has given a notice, he stands on a different footing
Yes.
because the statute protects them.
Right.
Similarly, every case you cannot bring within one umbrella.
Why I am bringing? Because under the same.
I say, because I find, if now I can recollect, their contention all along was that you have been developing your stand at the every stages. At one point of time, you took this. In second, you took this. In a piecemeal manner, you were doing it. If I correctly remember, this is what they say. And therefore, you are adamant that even a scheme is there, you will not follow that scheme. You will not follow that scheme. Then they said that 400 persons were appointed without undergoing a physical efficiency test, which you could not deny. But you said that it was a mistake. We did not go so deep into the matter. We say that we do not want to go whether mistake or not mistake. Physical efficiency test has been provided in the scheme. You have said they have to undergo with the physical efficiency test. But the only catch was that suppose if they do not qualify, then you say the medical test is also there. And if they qualify in the medical test, they will be considered for appointment. So this case, your contention is that the scheme in this judgment, the court has, or we have passed an order that bypass the scheme.
No.
We never said so.
No, I am not saying so.
So we never said so.
I see
We
that-
still say that yes, the scheme is there, you have to. Only question is whether if you have appointed 400% without the physical efficiency test, and they say that they are at par, you say the mistake, we say nothing doing. When you have taken a stand, if they medically found competent, fit to serve, no difficulty, you can appoint them. You can't frustrate the scheme in this way. Why the review? What the Supreme Court says, that a scheme has to be followed. Follow, we are saying that you follow. We never said a single word that you will not follow the
I
scheme.
appreciate.
So
I
we
have
never said,
disregard-
not a single word that you bypass the scheme.
My lord never said. So.
How?
Only thing we have
Review.
come, why you have come before your lordship 1 second? Because
Debarred.
there is a mistake
Debarred.
Debarred.
What mistake?
on our part.
No,
We are
sorry.
making submissions.
No.
Because I submitted being instructed by a person who was not able to instruct me.
No.
And this debarred, the word particular word.
What
an
debarred does
integral
not
part.
mean debarred from further participation or debarred from further consideration. The debar has to be construed in this perspective. In a context it is used. You cannot go and take an abstract meaning from the dictionary, what is the meaning of debarred, without the context in which it is used. It may be sometimes milder word can be used. At the time of dictation, some word comes that is used, but you have to read the whole sentence that what the court meant by that word debarred. Debarred means that the moment they fail in a physical efficiency test, then they are not allowed to go under the medical test. This is what is a debarment. Then we say that you have taken a stand that no, we will still take
That
them
can't
under
be
the medical
debarred.
test.
You said
We
so.
will. No, sorry. We have said in that line. If you want a clarification, we can do a clarification, but it
My
does
lord,
not
kindly
mean.
do that. I am
It's
submitting your
clarification.
lordship, kindly
Sorry.
clarify this.
If you are so much,
Yes, my lord. We are, this
so
is
much perturbed with the word debarred,
our- yes, we are really perturbed.
debarred.
Kindly make it clarified, and why today we have come to cite the or to make reference of 3 orders passed by this honorable court from time to time on the same cause prior to passing of this order by your lordship.
Sir,
on
we have
11th
we have
May.
taken into consideration all those orders,
No, my lord,
and we are saying so.
no,
We are saying
not,
so.
not all order. Please,
Come,
let-
come.
please,
May I make a-
other orders.
Come. Come.
But may I make a humble submission, bro, subject to my lord.
Other orders.
My lord, the order was passed on 11/5. 3 months' time was given. Their time expires on 10/8.
Kindly keep it on. record.
Therefore, their conduct, Lord, this is a frivolous application.
Justice Doctor's division bench orders and Justice Venumani's division bench order. These are
frivolous application.
on record.
Lordship will impose cost. I would pray, my lord, Lordship will impose cost.
we are amazed and surprised when an application for review is taken out. Assailing an order passed on 11/5/2023 to be reviewed on the basis of a subsequent order passed by the bench of co-equal strength. Full stop. Even if the ratio laid down in a judgment has not been accepted or overruled subsequently, comma, it does not efface the ultimate decision taken in the said judgment, nor would invite a review to be undertaken. Stop. Every litigation must reach finality. If this course is accepted and adopted, it will never bring any litigation to an end, nor to achieve finality, as any ratio laid down in the judgment may not be accepted or may be overruled after a gap of 10 or 15 years, and the person would still come and file an application for review that the ratio laid down in the said judgment has now been overruled in a subsequent decision of the court. So the review can only be entertained on the grounds or the parameters provided under Order 47, Rule 1 of the Codes of Procedure. In the event the court finds that there is an error apparent on the face of the record, there is no difficulty in understanding the court would review its own judgment/order. Even a review can be allowed on a discovery of new and important documents, which despite due diligence was not within the knowledge of the applicant on the date of passing the order. Full stop. The second criteria can only be applied in the event the document, though in existence at the time of passing the order, but could not be discovered despite due diligence. Full stop. We have recorded in the order dated 11/5/2023 that several judgments were delivered by the High Court as well as the tribunal were placed before us, which appears to be inconsistent in nature, and therefore it cannot be said that those judgments were not taken into account at the time of passing the said order. However, it is sought to be contended before us that another order passed by the division bench, in which one of us was a party. Now, a party, no, in which one of us
Comprise the bench strength.
one of us was a part of the bench. How I have started the sentence. In Kaji Ibadul Karim and others versus S. Bhattacharya and another, within bracket CPN 1235 of 2019, decided on 29/1/2021, could not be placed due to inadvertence And the order dated 11th May 2023 runs counter to this said order. We invited the attention of the council appearing for the review application. The reason for citing the said judgment, and it is submitted that in the said judgment, the earlier division bench in WPCT 74 of 2016 directed the following procedures to be adopted and or adhered to, which have been noticed in the said judgment, and the direction was passed upon the railway authorities to constitute a screening committee, which leads to an inescapable inference that the scheme was not the scheme was accepted by the court to have its operation, and therefore such a scheme cannot be whittled down in a subsequent judgment rendered on 11/5/2023. We notice the judgment rendered in Kaji Ibadul Karim and others Supra, wherefrom it appears that the prayer of some of the landlosers were turned down
On the ground of over.
on the ground of overage and non-submission of the documents. The division bench who rendered judgment in WPCT 74 of 2016 disposed of the said writ petition with the direction that within a period of 7 days from the date of the receipt of the copy of the judgment, the chief personal officer shall intimate the respondent number 1 therein which of the documents are required from the end of the landlosers for ensuring placement of his claim before the screening committee. It was further indicated that within a month from the receipt of such intimation, the respondent number 1 therein shall produce the necessary documents/papers before the chief personal officer, and upon receipt of such documents/paper, the claim of the respondent number 1 therein shall be placed before the screening committee for appropriate decision. The third direction appears to have cleansed issue in the said writ petition, where the court directed that while considering the case of the landlosers for appointment who have crossed 47 years of age, shall not be the authority shall not cite age bar as a ground for not considering the claim. And if the power of relaxation is indeed available, to consider the invocation thereof. The fourth direction in the said writ petition is inconsequential, as it contained a time limit within which the entire exercise is to be completed. So the court noticed the aforesaid decision and disposed of the writ petition filed by Qazi Ibadul Karim and others upon noticing that the authorities have unnecessarily created an impasse in contending that the document submitted is not in order, and there are discrepancies therein. A supplementary affidavit was filed in the said petition to cure the such discrepancies as highlighted, and on the basis thereof, the court directed that the moment the discrepancies have been removed, the matter may be placed before the chief commercial officer in terms of the order directions passed in WPCT 74 of 2016, and thereafter the screening committee shall consider the respective claims. We do not find there is any ratio which can be laid down impinging upon the scheme or contrary to the order passed in the writ petition on 11/5/2023. The issue involved therein relates to discrepancies in submission of the documents, and the court did not have an occasion to go into other nuances of the law or anything impinging upon this benevolent/welfare scheme framed by the railway board relating to appointment of the land losers. We do not find that simply because a judgment is passed would invite a review, provided the issue is identical and common and having decided earlier, and the latter bench did not notice the same and passed the order contrary thereto, there may be a possibility of exploring the provisions of review. The aforesaid observations may not be treated as sacrosanct, as it depends upon the facts of each case, and cannot apply and cannot be treated as a rule of universal application. However, a judgment which has no relevance to a core issue, even if not placed before a subsequent bench, does not invite the review to be made, nor we find any inconsistency in the directions passed therein. So far as the scheme is concerned, the court noticed the existence of a benevolent/welfare scheme framed by the railway board, and the tenet of the order does not give any impression that there has been any encroachment upon the said scheme or the said scheme has been whittled down. Stop. Even if we consider that the challenge to the said scheme rendered futile even up to the Supreme Court, and the judgment of the Supreme Court could not be placed on the date, on the said date, it does not invite the review of the order/judgment, as the judgment dated 11/5/2023 does not render the said scheme redundant or unworkable. Rather,
part of it.
the spirit of the spirit of the said judgment would
lead to an unequivocal conclusion that the scheme was accepted and held to be applied to the land users. Full stop. Interestingly, an argument is advanced that there is that the word debar, within quote, debar, used in the judgment dated 11/5/2023 have cleansed the issue and in effect overrides the scheme. Stop. We are unable to accept the proposition, the submission, unable to accept the stand of the applicant of the review applications. The said judgment was passed when a railway authorities disclosed their stand that even if a land user could not qualify in a physical efficiency test, he cannot be
Thrown out.
He cannot be thrown away from the zone of consideration for medical test. The words or the expressions used in the judicial order should not be interpreted in an abstract manner, but has to be read in the context in which it is used. Stop. Every word has a multiple meaning, and therefore it is a misconception in the mind of the railways authorities to segregate a word and interpret in their own way without venturing to go into the context in which it is used. It is a sheer wastage of court's time for such reasons to make a clarification of this word used in the judgment when there is no ambiguity in ascertaining its meaning if read conjointly with the context in which it is used. The word debar cannot be construed to have an absolute immunity over the scheme, but what is intended is that the land user cannot be kept outside the purview of the zone of consideration for the medical test in the event he could not qualify in the physical efficiency test.
Which was never used in other 400 cases.
Or
Grateful to you. I'm deeply obliged. Sorry for-
dismissed with cost assessed at 10,000 rupees to be deposited with the state legal services authorities.
Grateful to you. Kindly, I'm praying for your lordship for extension of time to comply your lordship's orders.
No question.
It was a 3 months time.
SLSA.
No questions, my lord. Your lordship will not allow that.
I can pray.
What are you talking?
Right. I can pray before your lordship.
He wanted to comply the order within a time frame. What more? 11th August is the last date.
Kindly
10th August.
2 months more.
Anniversary, if we take from a date to date. So 11 to 11th.
2 months more. Your lordship is granting that time.
15th,
But that is
August, September,
October.
October. Oh, the puja is intervening when?
Puja comes starts from 20th.
20th.
20th October.
Maybe a good
Not
news
cost
for the
50,000
pujas.
for this harassment. 10 is
Yeah,
too
legal
little.
right. Everybody
50
has
for
legal
that.
right.
Yes, legal right.
Okay. Now, it is, you are submitting on instruction. Now this gentleman has an authority. Third gentleman will not come and say that he has no authority. We are extending the time.
Yes, I'm seeking before lordship. But
Please, from whom you are taking instruction?
for a moment.
He has an authority.
Yeah,
We will record that.
Yes.
Please say that he has an authority to pray for that.
just a fraud. Cheating the applicants. And it will be an undertaking, Lord. Lordship will record that.
Don't sprinkle a
I have
fuel
no
to a.
other way out. Lord.
No,
If your Lordship goes
you
to
have
the
waited,
family,
you have waited for such a long time. You can wait for, if the good senses have prevailed, you can wait for some few days more.
Lord,
Sorry.
60, 70,
As
80.
Mr. Samanto is very energetic,
no,
that
no,
does
no,
not
no.
mean.
It's not that.
Will grant.
But
Let
Lordship
him,
will
let
make it
him
an
first
undertaking.
ascertain.
But I have received instruction, but my official saying, if your lordship will be so kind enough to extend 3 months.
No, 1 month is still practically not 1 month. Half month is still with you.
Half month is with us.
Up to 10th or 11th of August, the time is there.
Yes,
So we can extend from 11th to further 2 months.
lordship. Very well.
So it will go to September.
No, sir, not
Sorry, October.
October.
It will go to October.
October 20th or 15th October.
No difficulty.
Yes, no.
He has an authority.
Yes, sir. He can say he can give instructions only with regard to extension of time. He has
This is what I am asking.
yes, my lord.
No difficulty.
No difficulty.
After the dismissal of an application for review, the counsel appearing for the applicant, submits, on instruction from a person authorized in this regard.
Not authorized or my lord, alternatively, can he consider my submissions?
Then again, you will say that how you have asked it.
I have right to brave anything before lordship on behalf of my client.
It is the two different things. One is the prayer for extension and another is on instruction you are praying for.
This is my prayer for extension. Kindly consider.
That can be rejected.
That I leave it out. Since my lord consider everything, my lord, this is.
If you take a conscious decision, then we'll record it and then we'll extend the time.
But you kindly extend on prayer.
Extend, but let it be reasonable.
Or since that I do not want to put him in embarrassment situation because he's law officer, but that doesn't mean he has been authorized to say something to or to canvass anything. to the court.
Why I say so? Because on an earlier, when the order was passed, you have taken a different stand.
Yes.
That a person was not authorized to give those instructions. That's why we are now cautious.
He's not
We are
authorized so
asking.
far. He's not authorized as
let them
Then
take
how?
instructions.
Then how?
Come back
Who is
after
the
10
authorized?
minutes.
Who is authorized?
authorized is chairman.
Let him take consent.
10 minutes.
We'll come back.
But my lordship will kindly record it's an undertaking if they do it.
No,
Because
my lord,
otherwise, not again they will run away.
being instructed, I will say so.
Service jurisprudence is a different concept, Lord. That's why I'm telling this. It's not like your lordship's civil side, Lord. It is different.
Okay, now I have.
I know. I have seen your lordship
No.
from the very inception till today.
No.
But then, my lord, still there. If your lordship had recorded more things here, then this problem would not have cropped up, frankly speaking.
Yes. Next.
Grateful news. We'll be coming back within 5 minutes.
Even documents complete, etc., and they are filing review.
Next.
My lord, I'm petitioner for the content application, my lord, and this application has been taken last Friday, my lord, and even rule has been dictated, my lord, but it's kept in abeyance for the reason that for an unusual reason that advocate for the contemners has raised the issue that contempt application cannot be taken if the review application is pending. So my lord has given the time to the advocate for the contemners to produce any judgment or anything. That is.
Well, actually, I'm led by Mr. Kullan Kumar Chakraborty is out of state. But I prefer only 1 week time.
No, my lord,
Only one.
I object because you have
This
given.
matter was fixed in your presence, I think.
Lord. No, last occasion I was not present.
Last occasion, Mr.
Yes.
Kalyan Kumar Chakraborty was present.
Appeared, my lord. He actually.
No, Mr. Shovan Mukherjee, who is,
I'm.
so you appeared on 23rd of June.
Yes, my lord. On the previously I appeared, but last occasion, my lord, I did not appear. But actually, my lord, lordship in the last occasion, so far I have instruction. Last occasion, lordship is directed to file affidavit by all the contemners, all the respondents. My lord, among the respondents, some of them has been transferred. has been for the opinion proposition has been ready, but has not been affirmed up till now, my lord. It
My
requires
lord-
the IP only 1 week or 2 weeks time, my lord. as
My
per
lord, it was
lordship wishes, my lord.
rejected. Opposition filing.
No, that
composition-
was a composite application where opposition, we say in a contempt, it is not the rule. Every contender has to file a separate
Miller.
contempt, the opposition.
My lord,
Out of them, my lord, 3 has been transferred, my lord, to another.
So what?
My lord.
So what if the alleged act
My lord,
is
I bowed
when
down,
they were here, that they are responsible for that?
I bowed down before lordship, my lord. Actually, I just I want some time to file this application, my lord. They are in the outside of.
Where is
Another
the
station?
review application?
Lord, I'm not.
Where is the review?
I'm not aware about this review application. My lord, let the Mr. Kollan Kumar Chakraborty come, my lord, he will submit.
No,
my
no.
lord. I,
Sorry, you can't take it in this way. Where is Mr. Kalyan Kumar
my lord,
Chakraborty?
he is at Nagaland High Court, my lord. Kindly.
Sorry.
Only
Sorry.
1 week time, my lord.
No,
1 week. Or
No. No.
for the last 10 months, my lord, I'm stopped
No,
from
this is-
working and without salary, my lord.
Grant your time subject to the cost.
my lord, kindly, my kindly, my lord.
We'll grant
My
your
lord,
time.
my lord,
It is submitted
my
that
lord,
Mr.
keep it tomorrow, my lord. Keep it
Kalyan
tomorrow.
Kumar
Or day after
Chakraborty,
tomorrow, my lord.
he has gone to attend a case in another high court and therefore is unable to appear in the instant case. So, The review application has been, the review application is also filed. So the contempt application. And it is submitted by the petitioner appearing in person that he is neither allowed to resume his duty nor have been paid the salary since
Since 10 months, sir.
since last 3 months,
10 month, my lord.
10 months. We can't appreciate that a counsel who is appearing seeks for time as he has taken up a brief to appear in another high court. A government employee is knocking the doors of the court, and despite the order having been passed, is not only deprived of discharging his duties, but also the livelihood, as the salary since last 10 months have not been paid. In view of the above, though we feel that the matter should be disposed of in presence of the parties on merit, but the adjournment must be that, but it is a fit case where we should impose a cost.
My lord, I pray, my lord, kindly, my lord, kindly.
In that
My lord,
event,
keep it tomorrow, my lord. Keep
in
it
that
tomorrow.
event,
I'm
let
contacting
this
with
matter
him, my
be
lord.
listed.
My lord, kindly keep it tomorrow. I'm contacting with him, my lord, kindly, my lord.
Let this
I'm
matter
not
be
properly
listed.
instructed, my lord. Kindly keep it tomorrow. I'm contacting. with him.
On
Kindly,
Monday,
my lord. Any day, my lord, I'm contacting with him. My lord,
subject
don't
to the
impose cost.
payment of costs.
But don't impose cost, my lord. My lord, I pray people lordship.
My lord, they are really aware that my lord is going to the
My lord,
circuit
my
bench.
lord, you-
That's why they are making the excuses.
Very well, my lord, I'm contact. Kindly keep it at 2 p.m. I'm contact with him.
My lord,
Keep it at 2 p.m. Come. No, keep it at 1. You come at 1.
My lord,
Come at 1.
one.
1
Actually, he's on the way, my lord. I'm
I do
kindly
not
keep it at 2 p.m., my lord.
No, sir. 1. Chalo. Come at 1.
For the appellant, there is application for restoration and condonation of delay for filing the restoration. But your lordship was pleased to hear the order 41 matter. This is a suit for declaration of title and for declaration that
No,
the
no, condonation in a
condonation in respect of the application for restoration.
restoration.
That is why your lordship in the
Correct, correct.
decided to hear the order for trial.
Yes.
But this is a suit for declaration and declaration that declaration of right title and interest, as well as for a declaration that the deed of sale produced by the defendant are void, and for injunction. My lord, we had the plain,
Judgment of affirmance.
affirmation. Both the court we lost, my lord. Both
Yes.
the suit and appeal dismissed on the identical ground. There is no other ground. My lord, the fact of the case is very short, my lord. But for your lordship's convenience, may I hand over a piece of paper to
Genealogical table.
yes, my lord. My lord,
Yes.
kindly see the 3 rows. Side rows are not relevant. The middle rows is relevant. Well, schedule Q is the 422 decimals of land.
Yes.
Qazi Ali Ahmed was the original owner. After his death, my lord, Qazi Ali Muhammad, Qazi Sayyid Muhammad, and Salehan Nesa Bibi was inherited the property. And Qazi Sayyid Ahmed got 6 annas, 8 gandas, that is 169 decimal, middle row, my lord.
Yes.
And after the death of
Oh,
Qazi,
both sons equal, mother half. No
yes,
difficult.
yes, my lord.
Then,
And Qazi Sayyid Muhammad 116 got 169 decimal.
yes.
After the death of Qazi Sayyid Muhammad, his wife and 3 sons. So Khodatun Bewa got 29 decimal. He's the wife, 2 annas share, and Qazi Sayyid Masud got 49 decimal. That is Go schedule property. This is the relevant. And Qazi Sayyid 49 decimal, Qazi Sayyid 49 decimal, that is not relevant. But 49 decimals of land in schedule Go was recorded in the name of Qazi Sayyid Masud. But it is the case of the plaintiff that Qazi Sayyid Masud, he granted a power of attorney in India 1978 in favor of Qazi Imdadul Haq, but subsequently the Qazi Sayyid Masud died. Thereafter, his legal heirs, Laheli Masud, Sayyid Parvez, and Parveen Karima, they also granted a power of attorney in the same person, Qazi Imdadul Haq. And on the basis of the said power of attorney, deed of sale was registered in the year 2004, by which the plaintiff obtained acquired the property.
49 decimal.
Yes.
Then,
But the case of the defendant is that in 1974, there is a deed of sale executed by Qazi Masud. I have shown in the middle portion, right side. Deed number 612 of 1974. It was sold to defendant number 1. So this is a suit for declaration of our right title interest and declaration that the deed of sale being deed number 612 of 1974 allegedly in favor of the defendant is void.
why you say different party and different?
Yes,
party?
ma'am. That is the finding of the learned courts below. My lord, after hearing the both the court came to the conclusion but the suit was dismissed on this ground that the power of attorney dated 12th of 4/1990 was not produced
But this sale deed was executed by the constituted attorney or
by the constituted attorney. By the constituted attorney, and the said power of attorney was not produced before the court. So it is the finding of both the court below that though the defense plaintiff have to prove his case by his own independent and cannot be on the back of the defendant, though the deed is not relevant or void, but the plaintiff failed to produce the power of attorney. So My, my humble,
Secondly, that the same deed is executed by a constituent administrator to yes,
my humble submission is that this power of attorney,
the appeal shall be heard on the following substantial question of law. First, whether the court, both the courts below were justified in dismissing the suit solely on the ground that the deed of sale executed by the constituted attorney of the admitted owner cannot be held to be correct or sacrosanct, as the power of attorney executed in favor of the constituted attorney was not produced. Stop. Whether both the courts below were justified in declining to pass a decree for declaration on the basis of the deed of sale executed in the 2004 by a constituted attorney of the admitted owners, ignoring that the admitted owners never came forward and challenged the authority of the constituted attorney, nor took any steps to seek declaration of the said deed to be void. Requisites, lower court record by special messenger within a week. Requisites within a week. Paper book within 4 weeks from date.
restoration application and
Pratome restoration. This is an application for condonation of delay in filing an application for restoration. Stop. The another application is filed for restoring the instant appeal, which was dismissed for default on
it's not default on 5th of December 2019.
2019. The grounds enumerated in the aforesaid applications are similar and identical, and therefore we decided to proceed. We decided to hear out both the applications together. Stop. After perusal of the amendments made in the instant application, and upon and on hearing the counsel appearing for the appellant, we find that the appellants were prevented by a sufficient cause in appearing before the court on the said fateful date when the appeal was called on for admission and dismissed for default. So the petitioner has further explained the delay in filing the said application for restoration, which is also found to be sufficient. Accordingly, both the applications are allowed. The appeal is restored to its original file and number.
But being instructed from the competent officials, so I'm maybe you also want 2 weeks time, 2 months time. 2 months.
ठीक है तो आगे की बोले छी कोई मैटर है अच्छा ठीक है after the judgment is passed in the open court, the counsel for the applicant submits on instruction received from a competent authority that the time to comply the directions passed in the order dated 11/5/2023 be extended for a period of 2 months from date, from a period of 2 months. So we find that the period provided in the order dated 11/5/2023 has not expired, as it is due to expire
10th
on 10th/11th May 2023. August 2023, and therefore further 2 months time is granted to comply the said order.
Grateful you from the date of. That's it. Machu.
to be reckoned from the set date, that is 10/11 August
Eight.
2020.
10/. Next one. Much.
He
Everything
says
is,
one day before, I says on that day, no
On
difference,
that,
10 or 11.
everything is complete. My lord, it's an undertaking, my lord. Lordship will kindly record that.
no, grateful to you. So no more submissions. No either.
Everything is complete. They have to only give the medical test. That's all. I'm grateful.
This matter I am appearing for the appellants, my lord. Last occasion on 19th, my lordship, we are pleased to direct the applicants to present before this honorable High Court, my lord. The applicants at this stage, they are staying in Bangladesh, my lord. Bangladesh, my lord. It will take some more time, my lord. Kindly grant 2 months time, my lord, as a last chance, my lord. They are agreed to come, my lord.
Not 2 months' time. On the prayer of the appellant, let this matter be listed after a month.
Lord, kindly record the submission that the plaintiffs are in Bangladesh, my lord, because they are claiming, my lord, that they are residing in the same village, my lord. Kindly, my lord.
That
Grateful, my lord.
Yes.
My lord, may I please, Your Lordship? I appear for the appellant, my lord, here. This was an interpleader suit where your lordship, that we are the promoter. The flat buyer took a home finance from a bank with a tripartite agreement to which I am a party. If the bank terminates, the money goes.
Have you got the
I
calculation?
have given the money. I have paid, though it was extra, I have made the full payment. I've made a supplementary affidavit recording this fact with documents, and I've served, the logically gives me leave. Now, my lord, I need the protection for which I really filed the suit, because money was not the consideration. We could have paid then and there. My lord, here, my lord, because of the tripartite agreement, the bank has the right to terminate the agreement. The bank has terminated, and I wanted to deposit the money in court so that I am not accused by the flat buyer that you return the money. But I wrote to the bank that let me first sell the flat because you terminated the agreement. But the bank said to immediately pay up the money first. So they didn't let me time to sell the flat also. We could only sell the car parking and get 4 lakhs of rupees.
Maintainability was kept open.
Because interpleader, I suppose they are not very familiar with interpleader suits under Order 35. That's why we had come up from this order. Because that's not very common, lordship, interpleader suits. So that's understandably not familiar with it.
Not familiar with it. Why you did not argue? Make him.
No one took me. Not even my junior. So I don't let it not get passed on to.
So
And the lordship only sees one document, page 58. Page 57.
page
57 is the tripartite agreement between myself, the developer, the flat buyer, defendant 1 and 2, and Axis Bank. I am on clause 4 at page 59. It is agreed by and between the parties to this agreement that in case if the borrower fails to honor the commitment, the developer builder shall inform the bank, and the bank shall have the right to pay the sale consideration and get it registered either in bank's name or its nominee. This they didn't do. Likewise, in the event the borrower defaults in payment of installment, then in such event also, the bank shall have the right to inform about such default on the part of the borrower to the builder, and shall accordingly have the right to write to the builder for cancellation of the agreement executed between the builder and the borrower.
that default has occurred.
Has occurred number of times.
Bank installments have not been paid.
No, Your Lordship.
So the bank wrote, cancelled it. After that, the bank had 2 options, either asking me to repay the money or the
No,
bank.
well, one thing is that the bank can say that, please, since I have already paid the money, you execute the deed in my favor
That's
or his nominee.
we
Or
gave them the
secondly,
offer. We gave them the offer. You take it. You have to
they
look
say
for a
they
buyer.
wanted the money back. So in that event, you have a right to cancel.
No, I have, so they've already cancelled. Now
Cancelled the agreement with the borrower.
no, this is the agreement, the sale agreement, the
So
sale
it is-
agreement also.
They have a right to write to the builder for cancellation of the agreement.
Of the agreement.
Executed between a
builder and the borrower.
borrower.
So
So
this is
you
the-
have to cancel it.
No, they were right to write to the builder for cancellation of the agreement. Yes, so
Executed between builder and borrower means.
whereas the bank shall have
pending
right
purchase.
to pay the sale consideration.
Yes.
Now, Lordship kindly sees paragraph 6. It is hereby specifically agreed, confirmed by the parties to the agreement. In the event of default on the part of the borrower, as mentioned, the bank shall have the right, have the remedy available to the bank as is stated in clause 4 above, or have the right to demand the builder entire amount disbursed to the builder on behalf of the borrower with the interest due to the bank by recovering the interest so and so.
Correct.
But the builder agreed and confirmed that the builder shall have no objection.
So what do you want now?
So, I have.
They are not going to take any action. Now
So we have also cancelled. They have written to the bank. We have cancelled.
Then what protection now?
Look, the protection is the whatever money I have received from the borrower, less what I am entitled to deduct because of termination. That is in. I want to
the
deposit
matter.
in court. I want to deposit in court so that the court may decide what happens to the money. Because after all, we face consequences of the borrower then putting a claim. I can under Order 35 Rule 3 ask for an order since I'm putting in the money. There should be no one should claim against me.
No, that is up to you. That whatever the excess money which you have received, if you want to give
I
it
want
back,
to-
you
I want to give it back.
You can.
I want to
write
deposit the
the-
money in court. Lordship, this is the.
Why money in court? Why not you write to the, I do not know, why we will assume an advisory jurisdiction. But
Lordship,
you know the
Lordship,
best.
interpleader is somewhat an advisory because
But-
then I come to court and I ask the court
True.
to determine the interstate rights between the
No, that
defendants.
is what is the concept of interpleader suit. But now once you have already paid, so far as your grievance was that any action may be taken by the bank.
And also the borrower, both, because both will claim against me.
Correct.
That's why I want to
So
deposit.
you have liquidated whatever the amount due to the bank. No difficulty.
In fact, they ask for
They
excess.
have
I said-
repudiated that particular contract with the borrower. Now that is satisfied. So now there is no obligations either against you or against the borrower. They have got the money. Now the question is that you have paid back. Now the borrower has also given some money to you.
I want to pay back them. I want to deposit the money in court. I want to
This is-
deposit
this
the
is
money
what-
in court. That's the only thing I want. Because since I am discharged, I don't want to hold anybody's money. They will make a claim that you're holding on to the money. I want to deposit the money in court.
Wow, how much amount you have?
I have কত amount বলো লর্ডশিপ কত বাকি আছে 11,45,292 which I am still holding on after paying back the bank.
But the anti-suit injunction is a very difficult one, sir.
But that is at Order 34 under Order 35 itself provides that. This is not an anti-suit really. This is
This
Order
is really-
35.
Really, we are thinking of order section 41B.
No, this is not an anti-suit injunction.
This is specifically where
That is possible in very limited cases.
very limited case.
That's very limited cases.
Oh.
Lordship has granted in one of our
Some
cases
Mareva
arbitration.
injunction or anti-suit injunction, whatever.
Lordship has also granted.
No, we have, but
The
in a
Pradap
very,
Chatterjee and I
very,
did the matter before Lordship has granted.
in a
But
very
here-
special circumstances.
Second. Anti-arbitration injunction Lordships have granted. Yeah. Order 35 Rule 3. Procedure when defendant is suing the plaintiff. Where any of the defendants interpret the suit actually suing the plaintiff with respect to subject matter, the court in which the suit against the plaintiff is pending shall, on being informed by the court in which the interpleader suit has been instituted, stay the proceedings as against him.
That is what is the difference. If he has, then you can stay.
Yes,
the
but
proceeding.
here
Injunction.
I am
Injunction is a means.
so that this follows on
Correct.
sub rule 2.
Yes.
Rule 2, where the thing claimed is capable of being paid into court, the plaintiff may be required to so pay or place it before the court before he can be entitled to any order in the suit.
Correct.
That your lordship has
Now,
indirectly
any
done.
order means protection or something of
That's
that,
it.
but does not mean anti.
No, that is the protection because then sub rule 4, then rule 4. At the first hearing, the court may declare the plaintiff with discharge from all liability to defendant in respect of the thing being claimed. This is even more than anti-suit, and dismiss the plaintiff from the suit. And if it thinks that the justice or convenience, retain all the parties.
Yes.
So I am depositing the money, whatever remaining with me, and I want to be discharged of my liability from both
Now
sides.
the question is at the first hearing. What
I
is
have
the
served
first
them,
hearing?
they have not come.
Sorry. Then first hearing means
Before your lordship,
no,
it's a continuation
no.
because
The first hearing of the suit, it talks about on the first hearing.
first hearing of the not the suit. The first hearing, the
first
court.
hearing means what?
When
When the court really applies its mind, which is the date for settling the issues.
but that lordship, I
No,
do not
sir,
know. I would
under
not.
Order 14, you come.
But I would not venture a guess on that lordship. And I know this getting into law with my lord.
No. That is not.
I will
That
get
is what is the
bombarded.
first hearing. That after that, the court may, because you have discharged your liabilities, then court may proceed, award him a cost, and then dismiss the suit on that first hearing. When the court really applies his mind on if you come to order 14,
Order 14 is framing of issues.
that is what it says.
No, that is the commencement of trial. That is
No.
at the first hearing of the suit, the court shall hearing of the suit. But that's why here
That is
consciously the suit is not used.
At the first hearing means one has to give that first hearing means a hearing in the suit because both the parties are here before him, and then after hearing them, court find that you have already discharged your liability, and therefore can dismiss the suit.
Lordship then Lordship is importing the word suit into
What is the meaning?
I don't know.
Legal fiction. Legal fiction.
Legal fiction at the first hearing.
That what is really intended may not be appearing there, but deemed to have been in.
But it will not
At
be a
the first
casus.
hearing,
It'll
at
be
the first hearing means the court does not mean that on the interlocutory application is the first hearing. No,
It can't be a casus omissus, my lord. It can't be a
no, not casus omissus in
not a
that.
casus omissus. Because this is when
Not
the
a casus.
when the legislator did not use the word suit
No.
in order for
But the
35.
first hearing is always intended to be a hearing of the
Lordship, then give me at least the other protection that
what protection you want.
that I will not that the flat buses narrate the facts and record it. That's all. That will serve my purpose. That I have returned the money as per cancellation as per order of court, and I shall not be held liable by the defendant. Is after serving them. After serving them, I should be protected. Well, after order of court was there, I immediately paid the money.
ওখানে যেটা বলেছে at the first hearing, the court means first hearing মানে order 14 এর পর যখন এটা এসছে তার মানে হচ্ছে এখানে বলছে at the first hearing of the suit the court shall after recording the plaintiff written statement if any after examining and order 10 after hearing the parties ascertain upon what material proposition of fact or law the parties are recognized and shall thereupon proceed to frame and record them. That is why is the first issue is the first date of hearing of the suit. আর এখানে সুটটা ওয়ার্ড ইউজ করেছে এখানে সুট বলে না at the first hearing মানে এটাই বলছি when the court applies its mind on the basis of the facts disclosed by both the parties and the law applicable তখন ও বলবে না হলে তো ডিক্লেয়ার করে দেবে is discharged from all liability without hearing the defendant. এটা কোনো মানে হয়? How can you discharge a plaintiff from a
If they don't appear, my lord.
He say this is the amount. He may come and say that I have paid more. That may be a dispute. তো সেই জন্য শুধু ডিক্লেয়ার ওকে শুনে করে দেওয়া এটা মেকানিক্যালি ঠিক নয়। আর এখানে বি বলছে if things that the justice and convenience will require retain all parties. There must be all parties before.
No, we have served them twice. Lordship had asked them, sir.
That's the service of injunction. Service of summon is different.
No, there is the prayer is there for depositing in court and for with all those prayers.
But that is the service of notice. That is
Yes,
the
how-
service of notice.
that I have
under-
deposited
under
the
Order
money.
39 Rule 3. Service of notice under Order 39 Rule
It's not
3.
really Order 39 Rule 1 application. This is an application
Oh.
also under Order 35 interim application. Lordship, because the Order 35 contemplates and the money being or whatever property being placed in custody of court at the very beginning. Because that's the averment I have to make in paragraph as per Order 35 Rule 1 also. I claim no interest, that I have no collusion. Actually, I have none, because one flat buyer, because we have suffered. These flat buyers will then come and say, why did you repay the bank? You are in collusion with the bank. We have faced it. They go to State Commission, Consumer Forum, and here, but that's why did you repay the bank? There are 12 letters from us, from the bank, to the defend numbers 1 and 2, saying that this is the dues. Either you pay or you face it. 12 letters, but we face it, Lordship. As Lordships also know very well. Lordships have had commercial litigation, Lordship have done at the bar and also on the bench. For this is why we came on our own, paid the court fee and said, take the money, and we want to, because we can't stake our reputation.
But their presence is necessary.
How much time?
This is all done in the presence of the parties.
How many times will I serve?
That is a whole thing.
We have served, Lordship, directed, Lordship.
Because you have come and averred certain things. The other side have not disclosed. It is only the bank who has come and says that, look, this is what the agreement is. There is a due. This is a due. If you pay my dues, I am off. And in fact, you have paid the dues. Now the bank says, I have nothing. Now I got my money back. I'm concerned with my money. I received it. I have no claim. Neither in respect of the property intended to be sold, nor in respect of the parties. So now the party is against who is a borrower. He has to be here.
Then at least I understand. Then at least record that what Lordship said, that I'm entitled to cancel because I have
No, that is under the you need a blessing of the court.
But
if the agreement provides so, you can act in terms of the agreement. Who
because
prevents
as per order of court, we have repaid. Unless we get this protection at
an
least.
interpreter suit? If the party has come and this is what is the procedure also, that you can pay and get your slab
That's the whole thing.
discharged. Now this is what you have discharged
But Lordship, one
in
thing,
terms of the agreement.
But
It's in
Lordship,
terms of
I
the
had
tripartite
submitted-
agreement. So your claim against the bank or a claim of bank against you
gone.
is not there.
No, my lord.
Not-
My lord, so far, my lord, I had wanted to deposit the money and the court directs
That
payment.
you can do it. There's
Court
no
said
difficulty.
no.
But can we pass an injunction that now on deposit, you are precluded or prevented from instituting a suit?
That's what the Order 13, Order 35 Rule 4 provides. Rule 3, Rule 4 provide.
No.
Rule 4. And the other time, discharge of my obligation.
When? At what stage? That is what is the main issue.
Whenever the money is put into court, because
No.
that is.
It is what at the first hearing, the court may declare, that is what is a declaratory decree has to be passed, that the plaintiff is discharged from all liability to the defendants in respect of a thing claimed, award him his costs, and dismiss him from the suit.
See, that
And
was my first day's
when?
prayer. Lordship, I recall, I said I deposit the money in court. Lordship said no, you pay them directly. So it was like instead of depositing and the court paying, Lordship said instead you pay directly.
Because
to the party.
the agreement says that you'll have to. The agreement
Yes, so
says
half the agreement can't be
that's why we
preserved.
say don't deposit here because the claim would remain.
Absolutely.
So if they get it, now they are there. So your liability at least under the agreement is discharged. Now you are
Can we record
now,
that?
But the subsequent liability you can't, because if the borrower comes and say that I have paid the installments,
Then they let you sue the bank because then I have paid as per they let them recover from the bank.
but the difficulty is that if the bank has has done an hobnobbing with you and got away from
That's
there.
the only reason why I
That
came
is
to
what,
court.
that is what is the problem, because his presence is necessary. If he says that I have not, then
But
that is
that's
what
why I
I
came to
wanted.
court, so that he
So
can't.
that is why we wanted his presence to be here.
Lordship can read once more a service.
That
Lordship
is
kindly
what we
record that.
really wanted.
Lordship, we shall serve once more. Lordship kindly record that I have made payment. Give us chance.
Don't you know the address?
We have served. This is address as per agreement, as per the bank's letters also.
Then
Banks.
how the postal article came back or served upon them. How?
The doors are locked, they found. The doors are locked.
Look at
Huh?
it.
Addressee has moved.
Where?
That's the whole problem. Because Axis Bank also wrote to the same place. We also have been at the same place. Agreement address. Because this is. Because this is the address everywhere.
Do one thing. Make a publication notice. Thereafter, we'll see to it.
Or you at least kindly record that I have paid the money and I have.
Yes, definitely. We will record.
Your Lordship, I have only one submission. The money I have received, but the claim of my learned senior friend is that money is paid in excess. That is incorrect, Your Lordship, because as per the tripartite agreement, I am entitled together with interest.
I have given whatever I have
Yes,
returned. So
whatever
it is between the defendants 1 and 2 and them. I am not concerned whether you recovered extra.
The matter is listed today. To ascertain whether the calculation furnished by the bank on the outstanding amount as on 12/7/2023.
You may have can leave my lord.
কি বলেছি স্টার্ট করেছি has been honored and or implemented by paying the same to the respondent number 3. No, you are a respondent number 3. Respondent number 3. Today, the learned counsel appearing for the appellant as well as the respondent number 3 jointly submit that the entire amount in relation to an agreement, in relation to a tripartite agreement dated 24th November 2018 have been repaid, and the said respondent number 3 has no further claim against the plaintiff nor against the borrower, the respondent number 1 and 2 or 1.
1 and 2, Your Lordship.
1 and 2. The senior counsel appearing for the appellant raised for an injunction upon the said respondent number 2 from initiating any civil or criminal proceedings and further agreed to deposit the amount received by the appellant directly from the said respondents at the time either before or at the time of or on the date of execution of the said agreement. Stop. It is submitted before us that despite an attempt to serve a copy of the instant application, the service could not be done as the postal article returned with the remark door closed / addressee moved. According to the counsel for the appellant and the respondent number 3, the service was sought to be effected on an address disclosed in the said agreement for sale, and therefore it is not possible for the appellant or the respondent number 3 to know the subsequent address of the said respondent number 1 and 2. However, the reliance is placed upon the provisions contained under Order 35, Rule 4 of the Code of Procedure, that the moment the plaintiff has discharged plaintiff is discharged from all the liabilities to the defendants in respect of the thing claimed, the court may award the cost and dismiss the suit and dismiss him from the suit. So it is sought to be contended that the moment the entire money has been paid, there is no fetter on the part of the court to pass an order of injunction. The manner in which the interpretation of the provisions contained under Order 35, Rule 4 of the Code of Procedure is placed before us. We need that. It requires consideration. We also feel that before the court proceeds to pass any order under the aforesaid provisions, the presence of the respondent number 1 and 2 is necessary. In view of the fact that the postal article could not be delivered as the door was closed / addressee moved, we direct the appellant to effect the service through publication. The appellant is directed to take steps for publication of the notice in 2 widely circulated newspaper within the city of Kolkata, one in English and another in Hindi, because I find
Yes, Sultana,
yes,
they would be reading Hindi newspaper.
or Urdu.
Urdu is also available. I have seen Urdu newspapers, but I think Hindi is good enough.
Urdu
Urdu.
and other in Urdu. URDU.
And Urdu newspaper. Hindi will not everybody reads.
Do you?
But I am very, I am not very good with the script. I could at one point of time read. Now, Milord, I understand Marathi also very well, but reading both scripts is a problem for me. Very slowly I can read.
Hindi kore daw. Within a month from date.
Once can okay.
No formalities.
2 weeks is enough, Milord. We will come
within-
back in 2 weeks, Milord.
Within 2 weeks from date. No formalities. Now, all formalities pertaining to the publication of the notice are dispensed with. You did not have to go to the department and get it corrected. Are dispensed with. List the matter after 3 weeks.
I'm grateful, Milord. We'll also go and try to find them, Milord. Then I have also filed a supplementary affidavit for the, I'm sorry, an affidavit of service for the supplementary affidavit and the supplementary affidavit.
Let's go the next.
Grateful.
On the next.
My lord, advocate for the.
Sorry.
petitioners.
We have fixed at one.
8, my lord, I beg to appear for the appellant, my lord.
In this
The
matter,
last
my lord, I
question-
have instructions to appear on behalf of the respondent number 1. Service has been effected only today. In pursuance of
Yes, my lord. Up to this Sunday, we could not access the chamber of Mr. Chatterjee's, my lord. On the Monday, my lord, I have came up with a serve, my lord. He said,
Access the chamber of Mr.
Honorable Chatterjee, my lord, up to this Sunday, we could not access, my lord, due to the such a, on Monday, my lord, I have already served upon my learned friend's client.
But
we are
somebody
appearing
else
for
is
one.
appearing.
I have,
I'm appearing for one. I
last
do not know
occasion-
whether there are other respondents.
yes, my lord, I others one, we have already served to them. Post, my lord, it will take
Appears from
some
the
time
record
as
that
they
there are
all are
others.
deciding. And the, my lord, my instruction, where the matter can be settled. For
I have
that,
no
my lord,
instructions regarding-
4 weeks time, so far to my instruction, my lord, it can be settled.
It is submitted on behalf of the appellant that there is a possibility of getting the matter settled out of court. In view of the above, let this matter be listed after 4 weeks.
My lord.
Is next.
But in the meantime, service is to be effected. The other respondents, non-appeared.
Why you are bothering? You have been served, you are happy with that.
They are all my brothers and sisters.
So whether they will engage you, they know the service has been done. Yes.
Deeply obliged.
My item number 9, my lord, I am appearing for the appellant. And on the last occasion, your lordship heard the matter, but I am just recapitulating your lordship's mind. What happened, my lord? I am the developer. All the co-sharer entered into a development agreement with my client. Now, my lord, this plaintiff is one of the legal heirs of the one of the sister. Now, my lord, he is the husband. He is claiming 1/16 share. Now, my lord, when the construction, in terms of the development agreement, my lord, building plan has been sanctioned. Thereafter, my lord, construction has been done in substantial portion. At that juncture, a suit has been filed for partition. Although in the development agreement, the plaintiff's son was a party. Now, my lord, he is also entitled to a flat and the amount. Now, my lord, what happened, my lord, that a suit for partition was filed and the automatic one-line order has been passed as it is a suit for partition. Therefore, status quo in respect of possession, nature and character and also from transfer has been granted. I entered appearance and filed order 39 rule 4. The learned trial judge allowing the injunction application without deciding the order 39 rule 4. I came up before this court. This court directed the learned trial judge to decide the order 39 rule 4 within a particular period of time. Now, in terms of said direction, the order 39 rule 4 was taken up for consideration. But unfortunately, the reason for rejecting order 39 rule 4 is one of the grounds that if I can prove there is a misleading or there is suppression of fact, only order 39 rule 4 can be added. With due respect to the learned trial judge, if I can show to your lordship, now if your lordship see that in terms of the development agreement, I have already constructed a substantial portion. Now, after the order of injunction, I am totally stopped, and the building plan is yet to be renewed because it is going to be lapsed. Secondly, in terms of the development agreement, 3 tenants have been accommodated. I have accommodated 3 tenants. I am paying the rent. Now, 2 co-owners, 3 co-owners, I have also accommodated, but after receiving the summons, I stopped payment of rent to 2 co-owners because suit is pending. Now, in this situation, I beg to you before your lordship, kindly consider order 39 rule for application. I said in my order 39 rule 4 that the plaintiff claims 116 share. I am ready and willing to execute a supplementary affidavit, supplementary agreement with the plaintiff. He is at best entitled 116 share. But kindly see once my order 39 rule for application. Last occasion, it has fallen from your lordship that if matter can be settled, I had a talk with the learned advocate for the respondent. Now, the respondent who appeared in the court below. Now he says, my lord, that the other sisters are also entitled for more square feet flat, my lord. But they are not saying particular this plaintiff. Regarding other sisters also they are saying. Therefore, my lord, my client, but other my lord, defendants who has already entered into an agreement already in terms of the development agreement.
So,
No,
so what,
other sisters, my lord.
what he's saying?
But when I want to talk with them, they say that my lord, that I only my lord, this plaintiff is entitled 116 because other the defendants who are the co-sharers, they have already entered into a development agreement. They are entitled, my lord, whatever the terms and conditions. Now after this, my lord, when
For the
this,
plaintiff. Why are you doing?
Lord, regarding settlement, Lord, my client has come from UP, Lord. And what was, Lord, the observed by your lordship on previous occasion, I also communicated. It was fallen from your lordships that matter should be amicably settled. And Lord, my client is agreed to sit with the developer, but there should be some cooperation from the side of the play.
Yes.
my lord, only thing, my lord, what he, my lord, Mr. Ghosh is saying, what his junior is saying, that my lord, the other sister has to be give more square feet flat. But the plaintiff is one person. The other sisters are already entered into a development agreement. That is the objection of my client.
Why you concerned with your own share?
That should be.
And if the development agreement has been entered by the other co-sharer, and if they have said that they will get this much, then why you are bothering? You concerned with your share.
Yes, Lord, I am concerned with my own share, Lord.
Yes.
Lord,
Then why don't you, when you can sit?
But only thing, my lord, I've been just now told that in the court below also, my lord, a mediator has been appointed.
Now the advocate is here in the High Court. Why don't you sit with him together?
But last time I sat with him, my lord, he said that his junior will talk. His junior first word is that not this plaintiff, other sisters I have to give more.
He has said no. He's very candid that says, I am not bothered. I am simply bothered about my share. That's all.
That is why my client has come from UP, Lord, here.
So,
Can I record that and I send the matter before the court below? But that is my only prayer. But kindly see that I have stated. Kindly see my order certain rule 4. Kindly record this and kindly send the matter before the court below.
Why don't you settle it here?
Lord, they have admitted there in their objection that I am the co-owner, and
that is what he is not saying, that he wanted to sit with you and get it matter settled. We also said that when the majority of the shareholders have already, if you are inclined to settle your dispute, explore.
I know, when we will see again, they will say regarding the sister, because last time same thing happened.
He is here before the court, and he has candidly said so, that we are not bothering about the other. We are concerned with my share. We are concerned with
record the statement of that.
Everything is there. Yes,
Yes,
can't say.
The last commission also same thing has been happened, my lord. Same thing happened.
So, he's denying that he has never said so.
He is telling something about the advocate on the trial court.
Yes.
Lord, but this is my submission before your lordships today. Lord, so far as
sit and sort out.
Plaintiff is concerned, Lord.
It's not this week. In the meantime, you sit today or tomorrow. Get it.
But kindly keep it after fortnight, my lord. Any day, my lord. We will in the meantime see.
He has come, said from the state of Uttar Pradesh. He can't remain here for all time. Why don't you sit together when he is agreeable to settle it?
Lord, last Friday, my lord took up this matter and he came over here Sunday, my lord, for the purpose of settlement.
Last Thursday.
Anyhow, whatever. During this week, do it. Yes.
But kindly adjourn for fortnight, my lord.
Monday list.
Monday.
Let us see.
On my pair, kindly adjourn for fortnight, my lord.
Monday. One.
Grateful.
Extremely sorry, my lord, coming from Kohima, my lord, that is late, my lord, flight, my lord.
Yes?
I'm coming from Kohima High Court, so late, it was late.
Which?
Kohima High Court, my lord, Nagaland.
Kohima has a high court?
Yes.
Nagaland?
Yes.
I don't know. Because I think it's a Guwahati High Court which has.
It was deformed in the year 2016.
That is only in the Tripura and Manipur.
No, Mala, Kohima bench is there.
That is a bench
Bench,
of a
yes.
Guwahati High Court.
Not high, yes, Mala.
So you say Kohima High Court, I was
Kohima
surprised.
bench, Mala. Guwahati High
The
Court.
Kohima bench I can understand.
Yes, Mala.
Of a Guwahati High Court.
Yes.
Yes. What do you say?
Actually, after talking my client, Mala, that your lordship is absolutely correct, Mala. Evident opposition on behalf of Mala, that contempt, which I ready, Mala. But that is not Mala, affirm Mala, because of Mala short signature, Mala. Short signature, they are rejected their prayer. Your lordship kindly give some time, Mala, that I can give reply on behalf of Mala contempt.
Why don't, where is the review application?
Review application, Mala, that is Mala, can one, Mala.
Yes. Can we dispose of the review?
It can be, Mala. Only Mala, only one portion is Mala, that is Mala, not possible for myself, Mala, as a employee, Mala, employer, Mala, because Mala, as far as other point is concerned regarding Mala transfer issue, stay, Mala, area of salary, I have no problem, because re-engagement of that post, Mala, that isn't possible because Mala, another person has already been engaged, Mala.
Sir,
That is the problem,
I'm
Mala.
just simply asking you,
Yes,
an
ma'am.
order of transfer is challenged.
Yes, ma'am.
And the court has recorded that this order of transfer is passed in violation of the Supreme Court judgment.
Yes, yes.
The court has stayed the operation of the order.
Yes, ma'am.
Now the question is, I do not want, whether the review lies, if you say there is an error, tell us what is the error.
Mala,
If
review
you
only
say-
on one part, Mala, that part may be corrected subject to your lordship
Correct.
correction, Mala.
Correct.
That your lordship kindly come to Mala, last page of the order, Mala, page
Yes.
3, Mala,
Yes.
last para.
Yes.
Since we have stayed the operation of the transfer order, respondent authorities are directed to permit petitioner to join the post, which he held at the stage of pre-transfer order, shall also release all the admissible salaries benefit attributable to the said post without prejudice to their respective rights and contention.
Sure.
That same post, Mala, that is not possible, Mala, because Mala, that another person has already engaged, Mala, only Mala, that
Lord,
post
this is
only
false.
one post, Mala.
Misleading court.
According to my
My lord.
instruction, Mala.
My lord, there was only one post, and that post I was holding for 1 year. And after that, they have transferred along with the post to the Kharagpur. But that transfer is illegal. Why it is illegal?
The post is also transferred.
Yes, yes,
So
my lord.
now there is
along with
no
the
post.
But illegally, my lord. They,
Oh, that means there is no post. Once the transfer is along with the post, means the post which you held here was abolished also.
No.
And then that is what I wanted.
No, my
Post transfer. That is what I really wanted to know.
They didn't abolish the post. They didn't created the post.
So that is a different issue. They did not create a post there. But the moment you have been transferred, that this post becomes vacant on your transfer. And according to them, that somebody else have been placed in that post. You were saying that the transfer was along with the post.
Right, sir.
Means that post which was created here has been shifted to that post there. So the post is non-existent here.
But my submission is, my lord,
আমি জানি না। ওটা হতে পারে simultaneously এই পোস্টটা কে abolish করে দিল বা ওটা করে দিয়ে ওখানে একটা পোস্ট ক্রিয়েট করে দিল। That is what is it. আমি যেটাই ভাবলাম কিন্তু হচ্ছে না তা না। ওখানে কিন্তু পোস্ট ছিল না। একে এখান থেকে ট্রান্সফার করে ওখানে পাঠিয়ে দিয়েছে without any post. এটাই।
Post is there, Mala.
my lord,
The error is that divisional manager, Mala, without his knowledge, Mala, they have been taken into consideration reply of right to information that there have no post, Mala. And that should be, that is immediately, Mala, corrected from the Mala divisional office, Kharagpur, Mala. Now post is there, Mala, Kharagpur, Mala. And also this point has not taken into consideration before the trial court also, Mala. That is a fresh point, Mala. So you should kindly consider that.
So there is only one post.
Yes, Mala, one post, Mala.
Why don't you, who has come? Who has come from where?
That I
don't know.
My lord, there was
Shifted.
nobody has come.
You should kindly pass that order.
What order? Why will pass?
How can it be,
That is
Mala?
injunction.
How
You
can it
can't.
be,
You
Mala?
have to find out.
Because that is also,
That
my lord,
review cannot be,
he can go before the court, my lord.
no,
That is not his peer also, my lord. How can it be, my lord?
what?
That peer not taken into consideration by the petitioner also, my lord.
No,
One post shifted to another, and one person shifted to
no,
another.
he has simply challenged the order of transfer. That's all.
Yes, my lord.
That's all. And the court has found that it is contrary to the judgment.
The court is found, my lord, all the things that I have no problem with, because that post, my lord, one post, my lord. That post, that one person has only shifted currently, my lord. Another litigation has been taken into consideration, my lord.
So how
Subject
the
to
review,
correction, lordship.
how the review? Why not the modification?
Yes,
Then why review?
that is,
Where is the ground for review?
if we kindly liberty to
Or
file.
liberty? Why don't you pay him? Why you are insisting that he should go and join? We have said that you'll have to pay all. You have not done it. And the contempt is filed.
Contempt petition, my lord, filed subsequently, my lord, after filing review application.
No, my lord.
Whatever
I
is
have filed
the
the contempt petition first. Only after the limitation period of 30 days, they have filed the review, and they are not
And
interested.
opposition also
My
has
lord,
been
they are
filed,
not
my lord.
interested in the review.
That petition, my
My
lord,
lord, they are
the
avoiding
main
this bench and
petition
submit
heard before the
and
regular bench,
mentioning
my
to
lord.
the
That is
11 number
problem,
bench,
my
my lord. They are avoiding this bench just to avoid the contempt petition and mentioning in the court number 11, my lord.
to go and mention it.
Already mentioned, fix, the date fix also there, my lord.
Yes.
Yes, my lord.
Go-
Regular bench
go-
has already fixed, my lord, because of, my lord, that bench not sitting, my lord, this week, next week, my lord, Monday, my lord, it will be hard, my lord.
Review we have to hear. Review cannot be heard by any other bench.
Yes, my lord. That is
It's
true.
only this bench.
You should kindly dispose of this review application, my lord.
This is an application for review of the judgment and order dated 15th March 2023, by which an interim order was passed restraining the respondents therein from taking any coercive steps against the writ petitioner until further order, and also not to give effect to or act in furtherance of the impugned order of transfer. Stop. A further direction was passed that the petitioner may be permitted to join the post which he held at the stage of pre-transfer order, and shall also release all the admissible salaries and benefits attributable to the said post without prejudice to their respective rights and contentions. The review is intended not against the order staying the operation of the order of transfer or a consequential order relating to the or a consequential order relating to the release of all admissible salaries and benefits attributable to the said post, but on the ground that the posts which the writ petitioner, the post which the writ petitioner held has already been filled up, and there is no other post where the petitioner can be put in. The aforesaid contention is disputed by the writ petitioner and says that the moment the order of transfer is stayed, the said post is still in existence, and therefore the court ought to have, and therefore there is no impediment on the part of the respondents in complying the said direction. We are conscious of the power exercised by the court under review jurisdiction.
There is no case made out that the said order contains an error apparent on the face of the record, nor on a discovery of new and important documents, which despite due diligence was not within the knowledge of the applicant, or for some other reasons. The review is intended on a new facts which in our opinion is beyond the scope of the Order 47 Rule 1 of the Codicil Procedure. The compliance of the directions of the order is within the domain of the authorities, and review application shall not be is not entertainable as certain inconvenience is caused or perceived by the said authorities in implementation of the said order. We do not find that the position is such that it cannot be we do not find that the ground enumerated therein is inflexible and cannot be made flexible. Full stop. The authority, it is within the command of the authorities to take a decision if they have an intention to implement the order, and cannot seek a review on a ground not envisaged under Order 47 Rule 1 of the Court. Hence, the application for review is dismissed. Stop. So far as the contempt application is concerned, it is submitted by the counsel for the LS contemptor that the affidavit in opposition has already been engrossed, and in fact, the deponent signed the same, but because of the technical difficulties, the same is not affirmed, and therefore prays for extension of time to file the same. So in view of the above, the time to file affidavit in opposition to the contempt application is extended by 2 weeks from date. Reply, if any, shall be filed within 3 days thereafter. The contempt application is made returnable after 3 weeks.
My lord, kindly fix the date.
I think
My lord,
I think this bench may not be there from 2. We have to do a lot of